occurred at a Blue Goose Cantina at 2020 North Central Expressway in McKinney. That's Collin County. So the menu is mandatory there under 1502A1. Second, after the court's venue discovery, BGMXX corporate office, the place where its officers handle corporate affairs, has been 2020 North Central Expressway in McKinney since 2013. And that satisfies 15002A3. Plaintiff has a contrary showing that relies on a Dallas registered agent and an officer mailing list. That's located in Addison and Dallas. But a registered agent address and mailing address don't establish a principal office. According to
I couldn't tell from the briefing. Has there been any depositions taken in this case?
No, Your Honor.
Okay. Because obviously the registered agent doesn't really matter for that, but if it's where the decision makers are located and the officers are all located in Dallas County, right?
Yes, Your Honor.
Your Honor, that's not true. The office, there's one director. They don't function with the board of directors. There's just one director. That director actually does not reside in Dallas. She actually resides in Collin County. And the way the Blue Gooses work is each Blue Goose has a different investor. The investors then go to the locations. They have offices at all the locations, and that's where they make the decisions on each Blue Goose. The fact that there's a mailing address that's from 2013 and incorrect doesn't impact the location where the decisions are made.
Your Honor, if I may, there's been a lot of back and forth on who's actually making these decisions, but the Peterson family is who controls everything. And in our original pleading, we showed the Secretary of State, the website addresses that show director, president, and all of that being in Dallas County. They've since changed it, but it's still in Dallas County. They now have Nick Peterson listed as the director and president, and Todd Blankenship listed as another director and treasurer. All four addresses given there are in Addison. We've done discovery and they've been trying to hide the ball. I asked for office addresses of all of their officers and directors, and they provided me all residential home addresses of people. But the office addresses listed everywhere from the very beginning is that Jill Peterson was the president, that she officed down in Dallas on that by the Greenville location that's been there for 40 years. But every other office address we've been given has been in Addison, which is Dallas County, or there's now a Carrollton mailing address, which is also in Dallas County, and the registered agent is in Dallas proper. So every business address of the people that are making the decisions here, the people that are signing the leases, the people that are deciding where the restaurant's going to be, they're all in Dallas County. Now, the restaurant itself, the restaurant is in Collin County, but everybody who's making the decisions are in Dallas. And if you look at the case law and what the Supreme Court has said in Re Missouri Railroad, it doesn't matter where the day-to-day things are going on. It matters who's making the decisions and signing leases and who can do the hiring and firing and who controls. And certainly the president and the director are the ones that are making the decisions that control this corporation. Now, Blue Goose has numerous locations and they may have different investors, and they've got restaurants in several different counties, but the directors and the presidents are all doing business and officing in Dallas County, which is why venue is proper in Dallas in this case.
Your Honor, there's no evidentiary support for any of those statements.
And I would direct you to the leases and the articles of incorporation and the paperwork that's on file with the Secretary of State.
In Re Missouri, I'm sorry, Your Honor.
Go ahead.
In Re Missouri says it doesn't have anything to do with where the agent of record is, it has to do where the actual decisions regarding the location are made. Those decisions are all made in Collin County. The plaintiff resides in Collin County. The defendant, its employees, its records, they are all in Collin County. The medical providers, some of those are located in Collin County. Even if this is a venue choice and it's permissible in Dallas County, even if the court determines that, we alternatively request a convenience transfer based on the site, the employees, the records, the plaintiff, the medical providers.
I thought I gave you guys an opportunity to do depositions, didn't I?
Your
We
Honor,
were given, sorry.
I believe, Your Honor, is just a written discovery.
That would be unusual that I would do that. That's what the order says. Is that right or no?
I think that we were given the opportunity to do a deposition, and we did not do a deposition. We just did written discovery. And the reason plaintiff did that was because expense. We're going to have to depose the director later, and the expense of doing a deposition for this issue didn't. We believe it's covered in the written discovery. We've got a lease, we've got articles of incorporation, we've got Secretary of State paperwork. Throughout this whole process, the only thing defendant says is, oh, we make all our decisions in Collin County, but they don't give any reasons why. I have no reason to believe they're going to say anything different in the deposition.
I mean, my concern is not so. I tend to agree with you, but my concern is that if the court if we try this and goes to the Court of Appeals and we don't have any type of sworn testimony, I don't know that what you have is enough. You know what I mean? It's like that's why I give the opportunity to take depositions. I mean, what do their sworn interrogatories say?
Their sworn interrogatories they don't give reason. I can read it to you. Give me 1 second. And again, they objected to every interrogatory. Then we had to do a motion to compel. Then when you ordered them to answer these interrogatories, they gave me home addresses of all of these officers. So that when I asked for the location of the officers, they just said that the corporate office of BGMXX is and has been and continues to be at the McKinney location. It's their principal office since 2013, but they don't say why, and they don't identify any officers. They say they conduct their daily operations from that office, but again, they don't tell me anything about president, director, where they are. And then when I specifically asked for the corporate officers of the past 5 years with their last known office addresses, I was given home addresses for like 1, 2, 3, 4, 5, 6, about 15 people. I wasn't given any office addresses. But the mailing addresses on all the papers that were produced are all Dallas addresses.
I mean, the case law, if I recall correctly, is where the decision's actually being made on a daily basis, and or not on a daily basis, but where the decision's being made in this case. And it doesn't really sound like that issue has been resolved. I can understand why you believe that maybe in Dallas. And so, I mean, if you're telling me you don't want to go through the expense of the deposition, then I'm just going to transfer the case. I don't know how big this case is. Maybe it's not worth it to fight over it, but I'll give you one more shot to take the deposition. But
Okay.
otherwise, we need to.
No, we'll depose. That's fine. If you will allow us 30 days to get a date and a deposition, we'll depose the president or the director.
I am absolutely not available in 30 days. I apologize for that. And I would never say this, except I am booked for the next 30 days. I just got back from vacation, unfortunately. and my calendar is booked. Unless we would do a weekend.
Legal definition as to what
What, can I ask what the soonest date you can get a deposition scheduled is?
Looks like. I have a 2-week trial at the end of March, which booked me out in April. So I can commit to. I can try to get you in on April 21st if the client, if the corporate rep is available.
I'm available on April 21st.
I mean, your trial setting, though, the problem is your trial setting's coming up on May 19th. And that's, yeah, that's just too, given the history on this. All right. Mr. Keegan, what firm are you with?
With Cincinnati Insurance, Your Honor.
Okay. Do you have other counsel in Dallas?
We don't, Your Honor. They prefer one to two people in each office, and our other person just suddenly and unexpectedly left.
Hmm. All right, you guys are gonna need to do this deposition the next 2 weeks, and I'll give you an hour for it, so hopefully she can fit it in.
Okay, thank you, Your Honor.
And we're gonna reset this to March 30th. All right.
All right, thank you, Your Honor.
Thank you, guys.
Thank
You
you.
have a great rest of your day. And give
Thank
me an
you.
order on that, okay?
Will do.
Thank
May
you,
we
guys.
be excused?
You may.
Thank you, Your Honor.
Thank you.
Judge, did you want me to set that any particular time, or
I can't hear you, Rhonda. What'd you say?
did you want me to reset that at any particular time?
Yeah, reset it to March 3rd. What did I say? 30th at 3 o'clock.
At 3, okay. I'll let them know.
All right, our next hearing is Negrete versus Dallas Area Rapid Transit. Both sides here for that.
Yes, Your Honor. Rhiannon Kelso for the plaintiff.
Yes, Your Honor.
All right. Tony, let's go on the record on DC 256196, Negrete versus Dallas Area Rapid Transit. Counsel, make your appearances.
Ashley Ramos for defendant Dallas Area Rapid Transit.
Rhiannon Kelso for the plaintiffs, Jesse and Veronica Negrete.
All right, you may proceed.
Yes, Your Honor. DART sent out a request for production to plaintiff regarding past medical records from September 2020 through present, which is 3 years from the date of the accident. Plaintiff did not object, so she has waived all objections. We've been trying to get these medical records. After reviewing medical records, plaintiff is Jesse Negrete is claiming a left foot injury in this accident. He did have a surgery on his left foot. I've requested those medical records numerous times, have not received them. We are requesting the medical records for the surgery on his left foot. The only thing that plaintiff has stated is that he is not in control of the medical records, has provided a limited authorization, and is now requesting attorney's fees based on this motion to compel. So requesting that the attorney's fees be denied and the motion to compel be granted, plaintiff be ordered to produce the medical records within 14 days.
So I handled these pretty much always the same way. So was there an authorization to allow you to get the records?
Yes.
Okay, yeah, then that, if they have the records, they need to turn them over. Do you have the records, Ms. Kelso, or your
We
client?
do not, Your Honor.
So yeah, then you would be able to get them with the authorization. So, I'm not sure what else. Yeah, so the motion to compel is denied, the motion for attorney's fees is denied. Anything
Okay.
else today, guys?
Thank you, Your Honor.
That's all, Your Honor.
All right, give me an order on that, Ms. Ramos. It needs to say that this was heard on March 2nd, 2026 over Zoom. All parties were present. It was on the record and yeah, and just get that to me. And it was heard on again March 2nd.
Yes, Your Honor.
All right, you have a great rest of your day, okay?
Thank you, Judge.
Thank you, Your Honor.
You guys.